right, welcome back, ladies and gentlemen. I believe we are on episode 4.
Episode 4.
4 of many to come. And today we are going to talk about ALRs and why they are important. We touched about it a little bit last time, but before we get to that, Lacey G, our top G here, had something happen over the weekend. Tell me about it, Lacey.
I did. And first of all, I want to commend you, Mark Lassiter, because I have been learning so much and genuinely enjoying doing this podcast with you. It is informative, fun. But I had a friend call me the other night because she knows that I do a podcast with the Mark Lassiter Law Firm. And she said, my friend got arrested for a DWI.
Okay.
What does she do? So
you're able to just, hey, send her this podcast, send the link, look at this. It'll tell you what to do.
I sent it all to her. We've already covered a lot of bases. This is what you do when you're pulled over, which unfortunately she did not have that beforehand. We've covered what to do now for trying to pick out your attorney. Who do you want? How do you research to make sure that you have the right one? She's already there. She knows what to expect just from listening to this podcast. But the question is, she wrecked her car.
Okay.
Double the legal limit. Well, now she doesn't have a car to put a breathalyzer in.
Okay. Well, that's relatively simple, but let's ask this question first. How does she know she was double the legal limit? Did she do a breath test?
I'm not sure if she did a breath or a blood test. I do know that she did the field sobriety test. So that makes me believe she was compliant. So I would assume she didn't refuse, but I don't know that answer.
Well, for the ladies and gentlemen out there, let's just kind of recap here. This is a typical standard thing that happens all the time as far as an arrest, and I get these questions all the time. So let's answer them one at a time. The first thing is the reason I asked, how does she know she's over the legal limit or twice the legal limit? There is different levels of DWI. I think we talked about it in the first episode. So there's Class B DWI. That is first offense. And if you provided a BAC score, it was below a 0.15 at the time of testing. So those two things have to be true in order for it to be a Class B. If it is a Class A, which is the next level up, right below a felony, it is you either provided a breath or blood score that showed a BAC of above a 0.15 or above at the time of testing, or it is a DWI second. So because you're saying it's twice the legal limit, most people come in, they say, hey, we blew twice the legal limit, or our BAC was twice the legal limit. Well, that's not actually true. What it was is you were charged with something that is at least twice the legal limit or over. Most of the time, we don't do breath tests anymore because, frankly, they're not nearly as accurate as blood tests. And most police departments have just gone to, because lawyers like me question the accuracy of breath tests, we're just all going to go to blood tests. So first things first, I'm guessing that she was, and this is state of Texas?
Yes.
Okay.
Tarrant County, which I also want to know how far you cover in the DFW, but we'll get to that in a minute.
Everything in the state of Texas. In fact, the client that I met with this morning before doing this podcast with you was a Tarrant County case.
Okay.
So just send her to me. We will take care of it. But bottom line is I'm guessing it's going to be one of those situations where it's a blood test and it was above a 0.15 at the time of testing, so they're charging her with a Class A. Now, getting to the interlock question. Judges, by and large, are elected, right? So you have elected judges and you have magistrates that are appointed. So elected judges all the time have to, in order to maintain employment, get reelected. So in order to do that, one of the things that they do is they issue conditions of bond that they believe will protect the public so that they can go back and say, hey, we did our job as judges. We protected you, the citizen. So when we're talking about protecting you, the citizen, an interlock is a way that they can put something on a vehicle and say, because of the facts of your specific DWI case, we believe that you need to have some sort of protection that we can guarantee to the public that you're not going to do this again. So an interlock device is a breath device that goes on the ignition of your car. And what it does is you have to blow into it in order to start your vehicle. When you blow into it, it will detect if you've had any alcohol. Now, the quality of this breath testing device is, to me, in question because it doesn't necessarily differentiate alcohol. It goes back to the same problems of why we have blood tests now instead of breath tests, because there are a lot of different interferences that can cause an inaccurate or inaccurate reading. But all this to say, an interlock device gets installed on your vehicle that detects whether or not you've had alcohol and doesn't allow your vehicle to start if it detects over a 0.03. 0.02 and below, it will allow the vehicle to start, but issue a warning. Those starts, whether it be a non-start because of alcohol or a warning, will go to the pretrial services department in whatever county that you have the interlock requirement in. And that pretrial services will then send that to the judge and say, this person violated a condition of bond. So when you get out of jail, they give you conditions of bond. One of those may be an interlock in your friend's case, and you don't want to violate that because then you could potentially go back to jail. So in order to avoid that, you don't want to have any alcohol. But guess what? Almost everything we have has alcohol in it. Your perfume, mouthwash. I don't know why people get addicted to mouthwash right after. We kind of talked about that.
It tastes good.
But, toothpaste. So you've got to make sure that you don't violate those things. All this to say, she's got an interlock. It's going to have to be installed. Usually they give you a time period within 3 to 14 days. You're going to have to check in with Tarrant County pretrial services to ensure that you actually have that interlock installed. And they're going to want to know that, and then they're going to forward that information to whatever judge has assigned the case.
Well, but now she does not have a vehicle.
Right.
So
next
is
question.
there going to be any other kind of alcohol test? Is she not allowed to drink alcohol and she's going to have a different kind of breath test? Or does she just bypass that by not having a vehicle?
So all great questions, real simple. Is their goal is to ensure that you're not drinking. That's the condition of bond. So usually in these conditions of bond, it says do not consume alcohol, especially in Tarrant County. Tarrant County is very difficult to deal with. It's one of those counties that I don't know why, but they seem to have a burr in their saddle, so to speak, with everything that's going on. They're a big city that treats DWIs like they're murder cases.
Like worse than Dallas County is what you're saying?
Much worse than Dallas County.
Okay.
So sometimes part of the problem is you have prosecutors who have no real life experience, right? So they've gone through college where hopefully they didn't get anything or do anything wrong. And so they were never arrested. And then they go through law school, in which they didn't do anything wrong and they were never arrested. And then their first job out of law school is becoming a prosecutor. And then they're trained by other prosecutors who's never done anything wrong and never been arrested. So they don't know the trauma of what jail does to a normal person. To a person that's been in and out of jail their whole life, yeah, going to jail is no big deal. But for the average citizen, it is a big deal. It's scary. And they don't know and they don't acknowledge that simply having that arrest is terrifying enough that most people will never get arrested ever again in their entire life. But they treat them so harshly, like we're holier than thou. We don't make mistakes. Well, yes, you do. And if you had ever been through this scenario yourself, you would have more empathy for that person going through that. But I have found, especially in Tarrant County, that they are very hard to deal with because they are very non-empathetic. They don't understand that life happens. Accidents happen. And there's a just punishment for certain offenses and there's a not just. But all this going back to, that is a difficult county. And in order to get a device, right, where it says do not consume alcohol, if she doesn't have a vehicle, she's going to have to go back and get a handheld device until a vehicle can be obtained. because one of her conditions is going to be do not drive a vehicle that does not have an interlock device on it. So it's a handheld, and then usually once she gets a vehicle, we'll go back to the judge and say, hey, judge, issue an order to put this back on the vehicle so that she's able to have that and drive. Because right now she basically can't drive. And if she rents a car, she can't put it on the rental car. And even though her company or her insurance company will probably give her access to a rental car, you don't want to put an interlock device on a rental car. So basically, she's got to Uber until she decides to purchase a new vehicle, lease a new vehicle, whatever that happens to be.
Okay. And one more question. This is something that we discussed the other week, and I know the answer, but just to reiterate, she doesn't have a vehicle. She probably doesn't have money, but there's a reason why you don't go with court-appointed attorneys, correct?
There is a good reason why. Okay, so to explain what a court-appointed attorney is and what they do, we haven't talked about this before. Court-appointed attorneys make their money from the court. Now, I'm not saying that court-appointed attorneys are bad or that they have a conflict of interest, but if the person that is paying the bill is the judge and not you, who do you think the loyalty lies with in order for them to get the most favorable result?
It would be with the judge, with the county. Yeah.
That's paying the money, right? So what I'm suggesting is they are not as incentivized because the person that is doing the court appointment or public defender is not basing their salary and the rest of their remaining salary or their future salary on doing well for you. That doesn't mean that they won't do well. And there are good ones. I'm not saying they're not. But there are many that we talked about this before. You're just a number. You're not a person. They're trying to move your case as fast as possible. In court-appointed world, there's a lot of people that get flat fees, which means, let's say for your DWI case, I get assigned. The judge may say, I'm going to give you $100, just to use an example, to take care of the entirety of that case. Well, if I'm getting $100 for that case, I don't have time.
Putting in $100 worth of work. Yeah.
Then meeting with you is the amount of time that I want to put into that case. And then I want to move on to the next case. So I meet with you. I say, here's the plea bargain. Do you want to take it? Yes, you do. Judge, we got a plea. He pleads guilty, and I'm moving on to the next $100 client. And that's how I make my money. I have 5, 6, 7 of those a day. That's court-appointed work. Now, lots of good lawyers in court appointment, but the loyalty is divided.
And you don't get to screen a court-appointed attorney. You have one. You don't have a slew that you get to go up and ask all the questions that we discussed last episode. You just get someone, and that's your person.
You are assigned an attorney, and the judge assigns that attorney, and the judge is responsible for making sure that attorney is capable of handling the case. In fact, when I was the president of Dallas Criminal Defense Lawyers Association, there was a big to-do about, because they have to publish this, the county paying certain individuals a ton of money, like $500,000 a year on court appointments. And you're like, how is that possible? And you do the numbers, and they have somewhere between 400 or 500 active cases at any given time. And they are resolving cases at an incredible rate, a rate that suggests that there's no way that you could possibly look at all of the facts of the case and then advocate for that client the way a lawyer ethically should. So we put together a study that had been done by the Court of Criminal Appeals saying, look, most lawyers can only handle about 100 to 125 active cases and ethically be able to look at all of them for all of the things that you need to look at, discovery-wise, whether there's a defense, what the defense would be, if it needs to go to trial. All of those things indicate that these court-appointed lawyers that are having hundreds and hundreds and hundreds of cases, there's no way for them to actively and ethically represent. So when we talk about should you use and is it okay to use a court-appointed lawyer or a public defender, The answer is just like all the other lawyers. It depends on the lawyer.
Mm-hmm.
You've got to meet with them. If you cannot afford a lawyer, well, the system that we have allows you to have a free one. And in fact, if you go back to where this all began, it all began in English times. The guy named William Blackstone, who decided and published Blackstone's Law Dictionary, right? And in this legal dictionary, it defined Blackstone as an almost required reading. It's how you became a lawyer in the English times, in England.
Like
And
with the wigs? Is that
like with the Whigs,
Okay.
right? They used Blackstone as what's known as common law, as the authority for what common law stands for, what it should be, what is justice. And kind of going back on a history lesson, John Adams, our second president, became famous. The reason that he is the second president, the reason he became famous is he lived in Boston and he represented an English soldier that everyone believed had committed a crime. And I highly recommend watching the Paul Giamatti as the actor as John Adams from HBO. It's an excellent special that HBO puts out, just like the old ones. Not to give HBO a shout out for all their stuff, but Rome is one of my favorites. John Adams is a close second, and what it showed is John Adams as a court-appointed lawyer, right? They appointed him to represent a person that everyone hated, and he won the case by showing the bias that everybody had towards the English at that point in time, because the English were screwing us. But by showing the bias, he was able to get people to look past that, which is what a criminal defense attorney has to do. And because he won that case, he became famous. And that fame led to his appointments, led to his presidency, led to his involvement with the Continental Congress, everything. Because he was a hated figure for even representing that person. And then he swayed the jury and swayed the court of public opinion. That is a court-appointed lawyer that did an amazing job. You're going to have to, and your friend and whoever else is out there, you're going to have to meet with your lawyer. And if you decide that this person is not the one that you want, well, you're going to have to open up your pocketbook, because you need to find the lawyer, if you are charged with a crime, that is best suited to defend you. And if you don't do that, well, why in the heck do you have a lawyer? Use the court-appointed lawyer, because you don't care what happens to you. Now, what I run into a lot is, Mark, we like you, we want to use you, we want you to be our lawyer, but we have no money. Well, then it becomes a business, and that lawyer has to make a decision. Pro bono is not something that I do very often. There are certain situations in which I will do it, most of the time for military servicemen, because I was in the military.
Thank you for your service.
Appreciate it. But at the end of the day, it is a business and it has to make money. So even though I say, when you hire me, you are family, we got to get to the hiring stage.
Yeah.
Right?
Oh, definitely.
Because I have to dedicate that time, like I said, to the other clients that I have.
You're incredibly smart, talented, giving, but I don't blame you for that at all.
Would you tell my wife all that real quick?
You have to get paid for your services.
That's
of
right.
course, we have to be able to afford to live. You have a family. That's very understandable. I don't think that you should be taking on free cases, but thank you for the ones that you do for pro bono.
I appreciate it. So getting back to your friend situation, what we're going to do is we're going to meet with her. We'll talk about the facts. We'll go over the things that happened in the case, which leads us to the topic of conversation that we have today, which is ALRs. One of the first things, like we said in the past episodes, that we tell you about is the thing that you get is called a DIC warning. Now, a DIC warning is something that the officer is required to give to you, the client, right? Or you, the citizen. And it explains your rights. Now, he's going to read through it, and he's supposed to give a copy of you to read along with him. And then he is going to have to swear that he gave you a copy and then he read these to you. And at the end of it, he is going to ask you to provide a sample of your breath or your blood. And you will sign, and you don't have to, saying you refuse or you consent or you don't sign at all. I refuse to sign. He'll check that box.
Now remind me, is your driver's license automatically suspended, or is it according to blood count, compliance?
Excellent question. So the DIC covers all of this. And in the DIC warning, it tells you that if you refuse, your license will be suspended for 180 days. Now, interestingly enough, that's not true. That's what the ALR is, the Administrative License Revocation Hearing. So if you hire the right lawyer and you refuse, you have 15 days to try and save your license. And when that lawyer that you go to requests a hearing, your license cannot be suspended until that hearing has taken place. So if you refuse, you have 15 days. If you consent, they cannot suspend your license until they have proven that you are over the legal limit, which is a 0.08 at the time of testing, which is different than at the time of driving. So it's important to make that distinction, because at the time of testing is what it takes to charge you, but at the time of driving is what it takes to prove that you are guilty or not guilty. So when they do this under consent, in other words, officers asked you, do you consent to a blood draw? Yes, sir, I do. They need to test that blood. And provided it comes back at above a 0.08 or above, they will send the notice of suspension to you at that time. And typically what they do is they send it to the address that's listed on your driver's license. So this is a warning. Keep your driver's license current. If you don't, you will not get the mail that you're supposed to get. And then they have 20 days from the date that that notice was mailed, not from the date that you got it, from the date that it was sent, for you to request that ALR hearing.
You mentioned the other week that you never check your mail. I don't either. I have the mailbox across the street, never ever check it, to the point that I was getting no checks in the mail. I wasn't, all my bills are automatic. So it wasn't ordering anything. There was no reason for me to check my mail. Mark, I think it might have been a month and a half, maybe 2.5 months since I checked my mail. I went to the mailbox, cleaned out, had a notice in there that you have to come re-register. I did not even know that was a thing.
Because it was so overflowing.
That of what? Of junk?
Junk.
Well,
you get junk. 90% of mail is junk.
I didn't know that they could take away my mailbox.
So what they do is they say, we can no longer deliver mail to your mailbox. It's so full.
No, they said you have to re-register that you live in this house.
That's because they don't believe that anybody would not check their mail.
And why did I check my mail? Because I was waiting for a check. Because I finally had a check coming through. So I'm checking my mail and they had it.
So,
but you do have to check your mail in that case.
You got to check your mail. Mm-hmm. But if you consent, and let's say that they can prove that your license should be suspended. And the way that they prove that is that they have a reason to detain you, reasonable suspicion, probable cause to arrest. And in the event of consent, that you are above a 0.08 at the time of testing. If they can prove all those three things, they can suspend your license for 90 days. If you do not consent and you lose based on reasonable suspicion to detain and probable cause to arrest, that's what they have to prove in a refusal situation, then they can suspend it for 180 days. But like we were saying, none of that really matters, because we can get you what's known as an occupational driver's license. An occupational driver's license is a document that you send to the court and say, I would like to drive even though my license is suspended. The court will typically grant that depending on your situation with certain conditions. Either they'll have an interlock requirement, or they won't have an interlock, or they'll have restrictions regarding timing. You can only drive for about 12 hours a day is what the occupational license indicates. So you'll have driving times that you will indicate, I want to drive from this hour to this hour. You can break it up. You can make it all as one block, but nobody really drives 12 hours a day. Even if you're a truck driver, you're not allowed to drive 12 hours a day. So all of this to say, there's a way to keep you driving.
I live in Tarrant County. I do not drive 12 hours a day, but driving back and forth to Dallas, I do drive a lot.
Yeah.
Not 12 hours, but enough.
With the traffic, that's got to be at least an hour, right? One way.
Yeah.
But getting back to how the ALR affects your DWI, if the lawyer is good, he will do the ALR because the ALR gives him, like we were talking about before, the first shot at honesty from the officer because the officer has not had a chance to talk to a prosecutor and change his theory of the case and what happened. So you're going to get honesty from the officer. And I want to give some examples because we talk about this all the time. I am all about informing you, the citizen, what actually happens. And for you lawyers out there, giving you practical application. I've given speech after speech on this subject. ALR is the most important discovery step of a DWI. And if your lawyer doesn't do them himself, I really question or have someone that is capable, right, that knows the strategy, then it becomes a problem because you have negatively affected your ability to win. And as a lawyer, you never want to do that. You always want to give a better chance to win. That's the whole reason you exist. Otherwise, why have a lawyer? And to illustrate that, I want to share screen for a moment and show you some of the things that I have taught others about ALRs. Now, this is assuming that you've prepared. This is assuming that you've researched and you've determined your strategy. All of those things should happen before the ALR happens. So you should always request your ALR.
All right, how else can we get alcohol?
Yo, guys.
You should know.
Fogle, where have you been, man? You almost gave me a goddamn heart attack.
Go ahead and
Let me
cue the
see
video.
it. You pussy out or what?
No, man, I got it. It's flawless. Check it.
Hawaii. All right, that's good. It's hard to trace, I guess. Wait, you changed your name to McLovin? McLovin? What kind of a stupid name is that, Fogle? What, are you trying to be an Irish R&B singer?
Oh, they let you pick any name you want when you get down there.
And you landed on McLovin.
Yeah, I was between that and Muhammad.
Why the fuck would it be between that or Muhammad? Why don't you just pick a common name like a normal person?
Muhammad is the most commonly used name on earth. Read a fucking book for once.
Fogle, have you ever actually met anyone named Muhammad?
Have you actually ever met anyone named McLevin?
No, that's why you picked a dumb fucking name.
Fuck you.
Give me that. All right. You look like a future pedophile in this picture, number one. Number two, it doesn't even have a first name. It just says McLovin.
What? What name? What name? Who are you, Seal?
Fogle, this ID says you're 25 years old. Why wouldn't you just put 21, man?
Seth, listen up, ass face. Every day, hundreds of kids go into the liquor store with their fake IDs, and every single one says they're 21. Just how many 21-year-olds do you think there are in this town? It's called fucking strategy, all right?
Let's stay calm, okay? Let's not lose our heads. It's a fine ID. It's gonna work. It's passable, okay? This isn't terrible. I mean, it's up to you, Fogle. This guy's either gonna think, here's another kid with a fake ID, or here's McLovin, the 25-year-old Hawaiian organ donor. Okay, so what's it gonna be?
I am McLovin.
No, you're not. No one's McLovin. McLovin's never existed because that's a made-up, dumb fucking fairy tale name, you fuck!
Jeez, man, it'll work. Give it a chance.
Now
All right.
I want to go watch that movie.
Yeah, so we got to do a shout out to Superbad there. Stole a clip from you. But to give the audience an idea, what they were doing is they were trying to buy beer for a party that they were going to host. And they had this great plan. Hey, we got a party. We're going to be able to provide the alcohol in high school. This is a great thing. You know, we're going to be able to actually do what high school boys want to do.
Mm-hmm.
And in order to get the alcohol, they had a plan and they tried to execute it. But unfortunately, they left it in the hands of the wrong guy, kind of like leaving it in the hands of the wrong lawyer. And when they trusted this guy to go out and get a fake ID that would be passable, that would allow them to purchase the alcohol, he gets an ID and calls himself McLovin, right? It was a great strategy until the execution. So they didn't use the details that they needed, right? And if we're going to like synergize this with lawyers and do the analogy, the lawyer needs to be trusted. The lawyer has to be able to go out and execute the strategy that you guys have decided upon. So when we talk about ALRs, you must decide upon the strategy before you walk into the ALR. Now, it may change, but you need to have a strategy. You need to have done the research, because if you don't do those things, you're not going to be able to ask pointed, intelligent questions. As I tell everybody, all the lawyers out there, an ALR is the single greatest tool that you can possess, right, to win the DWI. It is the single greatest tool. And when you do one, do not just cover the basics. Do not just go, hey, did you give him the field sobriety test? How many seconds did you go out on your passes for the HGN test? How many questions did you ask him, or did you ask him about injuries before you did the walk and turn and the one leg stand? These are generalized questions, and where they can provide some benefit, they are not what a good attorney should be doing. A good attorney nails the officer down, and he nails them down on the strategic questions that they need answered in order to win the case. Now, I've told you this, Lacey, I am not just about tooting my own horn and telling you what to do, because that does not help. If you're a lawyer out there, you're like, hey, what am I actually talking about? How does this apply in the real world? Well, we're going to teach you, because we're going to show you practical application for what I am talking about. If you could just share the screen again for me. And here it is. Execution. All right. The first thing that you have to do is be nice. Right? What do they say in Roadhouse? Be
Kick
nice.
stuff. Oh, okay.
You need to work on your Patrick Swayze. All right.
It's been a while since
You
I've
would
seen
think
the
that
movie.
you, of all people, like every girl should watch Roadhouse, because that's what they want, is a cooler, right? Who runs the bouncers. All right. So in Roadhouse, they had this whole big speech by Patrick Swayze. And he goes, if they're mean to you, if they spit in your face, if they kick you, be nice and escort them to the door. The first thing that you learn about officers is that you get more bees with honey. Mm-hmm. So be nice.
And they hold the power. You shouldn't be mean to people in general. Let me say that. But also someone in power who has control over you in that moment definitely would not recommend being rude, being mean, being non-compliant.
Well, I'm going to give you the perfect situation, right? So when I'm in these ALRs and I'm being nice, there's a reason I'm being nice. I may not want to be nice. I may think that they're just lying their ass off. However, let's take a recent example. Last week, Tyreek Hill gets pulled over in his supercar on his way to the stadium. He's actually right outside the stadium. The body cams have been released. The officers were incredibly aggressive. Like, we're not going to make any bones about this, ladies and gentlemen. The officers should be reprimanded for the way in which they conducted themselves with Tyreek Hill.
That's an NFL star?
That's an NFL wide receiver on his way to the stadium, gets pulled over for some sort of speeding. And the officers were asking for his ID. He rolled down the window, and then he rolled up the window, and then they got very aggressive with him. And they said, no, you roll down the window right now or else. And then they said, or else we'll get you out of the car. And they said, you know what, just get out of the car. And then they start yelling. They yank him out of the car. They throw him on the ground. They put him in handcuffs. All of this is an escalation. None of it needed to happen. And it is unfortunate in our times. If that had probably been a person that was white, this wouldn't have happened. And that's real. Mm-hmm. It would not have happened, in my opinion, if that person was white. And the reason for that is that officers sometimes feel more of a threat from the black community or Hispanic community than they do from the white community. Now, why that is, that's probably goes to statistics and a bunch of other things that we can't go into at the moment. But what I want to say is this: notwithstanding that the officers were in the wrong, do you think that if Tyreek Hill had simply been nice, that would have happened?
I'm not familiar with this person or what happened, but yes, I do think if you if you respond nicely, that there's a good possibility you could also get a nice response.
Well, this is what a typical traffic interaction would look like. You walk up, the officer walks up, you, the individual, know the officer's after you because you've pulled over. You roll down your window, you hand him your ID. Sometimes he asks for your insurance. You show him that. He says, okay, I'm going to go run a check just to make sure there are no warrants. He comes back, he either gives you a ticket or a warning. And let's face it, none of us want a ticket. So we're always super nice to the officer. Mm-hmm. Hey, man, I'm sorry. I didn't realize I was going that fast, or I didn't know my brake light was out, or whatever. I didn't realize my sticker had expired, right? My registration, whatever it is. We're trying to get out of it. Mm-hmm. The way that we're going to get out of it is we're going to be nice to that person. Well, when you're a dick, it doesn't make the officer want to be nice back. Mm-hmm. So I'm using that example, not going into the details too much, but to say, look, everybody in that situation could have done better. The officers are completely at fault, even though Tyreek probably didn't treat him as nicely as I would have wanted to be treated. I don't think I would have reacted the way the officers did. If I wanted to give him a ticket, which is what Tiger is saying, just give me my ticket, I'll be on my way. Just give him the ticket, right? You don't have to be nice to cops as citizens. However, if you want the cop to be nice back, you need to be nice. So in these ALRs, ladies and gentlemen, lawyers, I'm talking to you, be nice. The questions don't have to be combative.
Also, might I suggest not giving dumb excuses. I know one time traveling far, coming back to see my grandmother, I got pulled over twice for speeding because I didn't listen the first time because I'm driving long distances. And I believe it was very long ago, but I believe I got a ticket the first time. The second time I said, there's an emergency. I'm trying to get to my grandmother and my tire's messed up and I need to hurry up and get there. And they're like, don't drive fast on a bad tire. And I got a ticket. Like, no. Why did I have to bring up the tire? I don't know, because I'm a horrible liar. I should have just been nice and probably not been speeding in that moment once again. But
there's times
it
to be
did not
honest.
Get me out.
There's times and there's times not to be. But I say that there's times just to keep your mouth shut.
Yes,
right.
And say, with all due respect,
talk to my lawyer.
I need to call my lawyer, Mark
That's right.
Lassiter.
So getting back, the first thing that we need to do, ladies and gentlemen, lawyers, is be nice, right? The reason, obviously, is as we've been talking about, and in addition to that, is the judge is not going to like it, and a jury is not going to like it if you're not nice. So you need to ask your questions nicely in this ALR because you're going to get a transcript. And you want to be able to read this to a jury. And if you're not nice, if you're not matter of fact, asking a simple question and asking for a simple answer in return, a jury's not going to understand and a judge's not going to like it. All right. The second thing you need to do before you go into the ALR is have your evidence ready. You need to have everything that you had prepared, right? The research, the documentation, scientific or otherwise, ready to go to question the officer in the event that he veers in a way that you don't want them to go. So one of the things that officers try and do is they try not to answer the question. So for instance, if I asked you, Officer Jones, did you know the defendant before today? You'll say no. Well, how do you know that this was slurred speech for that particular person? And they'll dance around the issue and they'll be like, well, that all I could tell you is that I heard slurred speech. So you would agree with me that you did not know whether or not the speech was due to alcohol or not. You want to make sure you nail down the officer in his responses. And you need to know when the witness is being inconsistent, which leads us to our third thing, which is know your case. If you don't know your case, then you don't know when they're being inconsistent. Go ahead and flip it to the next slide, if you would. So this is our practical application. So we have a client who says he wants to plead and he had no chance to win. Doesn't remember anything. And this is one that we used as an example the other day. And that he had flipped his car over upside down into the house. Now, if you'll flip it to the next, this is the police report where there appears to be no basis for the suppression of the evidence. In other words, the case is going to go forward like normal. If you look at it, on the bottom, they have bloodshot eyes, slightly slurred speech, an admission of drinking. All of these things, odor of alcohol, tend to indicate late at night, flipped a car into a house, a person that is intoxicated and should be investigated. All right? So they need to be detained for an investigation. Go ahead and flip it to the next one. There's definitely a reason for the contact. There's a major accident. The officer's flagged down by a citizen. There's definitely a reason to investigate the accident, the odor, the bloodshot eyes, the admission, and there's seemingly no chance to win with a person who's 4 times the legal limit.
And I'm assuming nobody was hurt in this incident.
The individual driving, so the client actually had some injuries, but they were minor.
Okay.
Nobody in the house. Go ahead and flip to the next. This is where it matters. This is a transcript from the ALR, from that individual. The only reason we were able to win this guy's case is because this was done the correct way in an ALR. And so this is me questioning the officer. I asked her, as close as you can, as a female officer in this case, if you can tell me as close as you can what you told Officer Watkins. Officer Watkins being the investigating officer in this case who ended up making the arrest. But he was not the detaining officer. The initial detaining officer was this individual. She told me in answer to this question, I was flagged down to an accident. I had to get the driver out of the vehicle, and I smelled the odor of an alcoholic beverage on his breath. And my question was, and you asked him being Officer Watkins, to investigate. Next page, please. So this is the remainder of that questioning. And in it, what you can see, and it'll be at the top left of page 1, did you see any other signs of intoxication other than that? Now, why does this matter? Because what she's told us is she has the odor of an alcoholic beverage. But in the police report that we showed you earlier, it seemed to indicate that she had bloodshot eyes, slurred speech, and admission of drinking. That's not what she testified to in the ALR, because in the police report, most people don't realize this, they're not always written by the person who observed those things. In this case, it was written by Officer Watkins, who was not the responding officer. He wrote what he was told, but that may or may not be true. So we get it straight from the horse's mouth. Did you see any other signs of intoxication, or did he go straight to the fire department and straight to the hospital? And her answer was he was immediately placed on the ground due to the fact that he was involved in an accident. That's typical. You want to stabilize the head. They put him in a stretcher, and then he was immediately transferred to the hospital. So instantly, I am thinking, well, now hang on a second. She didn't say anything about any other signs of intoxication. So we further question that. My question was, would it be fair to state that your next phone call was for a DWI unit? And you said, I need somebody to investigate this because I smell the odor of an alcoholic beverage. And she said, Bobby Watkins is the officer, had already been notified to come, to respond. And I said, okay, describe that. And her description was, I believed that there was a chance that he was intoxicated, is what she's referring to. And I go ahead and ask that they send someone so that they're not caught up in another call. So what that means to me, I'm hearing this for the first time, is I go, wait a minute, you sent an officer to the hospital to detain a person simply because you did not want them to be caught up on another call on the off chance that they might be intoxicated based on the odor. And I clarified that. I want to make sure that's what they're saying. So my question was, when you say there is a chance, would you say that you have no knowledge at the time, one way or the other, whether or not he was intoxicated, right? Her answer was, when I got him out of the vehicle, that's correct. And then I followed it up with another question. And that chance is akin to a hunch. A hunch, ladies and gentlemen, is you don't know one way or the other, and it is not akin to reasonable suspicion. In other words, it does not meet the standard necessary to detain. And later on down, I make sure that that is the totality of her involvement with the case, is that she observed the odor alone. She called for a unit and had one dispatched to detain the individual. And when Officer Watkins got there to the hospital, he detained the client to investigate for DWI, and the entirety of the basis was odor of an alcoholic beverage. That's it. And due to that, we won. We researched the strategy. Okay, and we're going to go to the decision point, which is in the motion to suppress. We used all of that we just discussed, the ALR, to prove that they didn't have a right to detain, and the motion to suppress was granted.
Because you're saying they arrested him without having the evidence, because they hadn't taken breath sample, they hadn't taken a blood sample yet.
That's an excellent question, and it's the misnomer that most people don't understand. There is a difference between an arrest and an investigation. In order to detain someone, you need to have reasonable suspicion of a crime, specific articulable facts. In this case, odor of an alcoholic beverage alone is a fact, but it is not specific and articulable enough to indicate that a crime has occurred, will be occurring, or is in the process of being, or a process of occurring. That's what they have to prove. In this case, they didn't prove that, and we won.
And they didn't, or was unable to do other investigating. They couldn't do the field sobriety test on this.
Well, there are things that they could have done.
Mm-hmm.
And that's the difference, is saying, look, we're not saying that there wasn't a way in which he could have been investigated.
Mm-hmm.
But the way in which he could have been investigated is asking questions related to the accident, discovering whether or not this individual had other signs and symptoms of intoxication, then using those signs to initiate an investigation. Then after initiating investigation, determining based on those, the facts that you gather, there's enough probable cause. So if you would go to the practical application example number 2, again, we're talking about ALRs. So in this practical application, we have in the interview, the client tells me he was stopped for unconfirmed insurance. Well, what does that even mean? Unconfirmed insurance. That means you don't know one way or the other, right? That seems to be the definition of unconfirmed. You don't know.
How does that happen? They run your plates and think that you don't have insurance, or it's not a nice car and they assume you don't have insurance? How do you get unconfirmed suspicions?
So when an officer is driving behind you, they can look at your license plate. They can run your plates while you're driving, and it will tell them if your insurance, if you have it, and it can also tell you whether or not your registration is expired for that vehicle. So what they'll do is they'll look at that and they'll say, hey, his registration is expired. We have a reason to detain, which is a traffic violation. He has no insurance. There's a reason to detain. That's a traffic violation. In this case, when I'm doing the initial interview, and this is in Tarrant County, I hear unconfirmed, and instantly I'm going, well, wait a minute. That's not enough. You need to know one way or the other. If it's simply unconfirmed, that's not good enough. So I recognize the suppression issue. I know I need to do some research, because there was a recent case at that time that said, if you say as an officer unconfirmed means that they don't have insurance, that is in fact good enough, because it's saying this person doesn't have insurance, therefore I get to detain. So we do our research. We go through the process that we just described. All right. In the police report, I verify, as you can see here, a computerized search of the vehicle yielded unconfirmed insurance. So now I've verified that the officer said it in their police report. I do the research on the case law. And go ahead and flip to this slide if you would. So I know for my strategy in the ALR, I need to ensure that the only reason for detention is unconfirmed insurance. I need to get the officer to admit in the ALR, unconfirmed is not the same thing as no, because I've done the research.
And to clarify, if they're running a license plate, it's either yes or no. Unconfirmed is not a thing, or I guess you just said it's not a reason. Unconfirmed is
Unconfirmed is not a reason. You need
Okay.
to know one way or the other.
Okay.
Now, many officers have now resorted to saying unconfirmed means that they don't have insurance. I don't believe that's true, but that's what they're saying.
Mm-hmm.
And the case law indicates that an officer can say that, and that can provide justification. So I know for my strategy in this ALR, I have got to get the officer to admit unconfirmed means unconfirmed. It does not mean they have no insurance.
Okay.
I have to get the officer to admit the client was stopped so that solely they could determine one way or the other if they had insurance or not. And so the plan was to make sure that I got that information. And if I got what I wanted, remember, if I win the ALR, I don't win the case. I just win the license hearing. I need to use that in the motion to suppress because they're probably going to change their story. So let's go to the ALR. This is the transcript. All right. This is, again, a female officer. Ma'am, you're not understanding the question. Prior to running his insurance, did you observe criminal behavior? Her answer was no. And you had no reasonable suspicion that he had committed an offense, right? That's correct. Prior to running his insurance, you did not observe any criminal offense, correct. And prior to running his insurance, you do not have any reason to believe he was about to commit a criminal offense, correct. So what I have done is I have eliminated reasonable suspicion of any other crime other than not having proper insurance. That is important for you lawyers out there. You have got to make sure that you are dealing with one specific issue, or if you're dealing with two issues, you need to know exactly what they saw, because there's a case out there that says even if you didn't see it, if you didn't see it at the time, you can't make it up later. In other words, you can't watch the video and say, oh, there's a traffic offense out there. I'm now noticing that. That cannot serve as reasonable suspicion. You have to have observed it at the time.
And have it in your notes or document
You don't
or
necessarily
whatever.
have to have it in your notes, but you
Okay.
have to have observed it. So what I'm doing is under oath, I am getting that officer to commit I saw nothing else.
Mhm.
That is very important. Going to the next slide. All right. My question, unconfirmed insurance is not the same thing as no insurance as far as it reads on your screen, correct? Her answer was correct. So when you have a screen and you're running insurance, it will say he has insurance, he doesn't have insurance, or unconfirmed, right? Her answer was right. And my question again, those are three separate responses, correct? Her answer was correct. And then I followed up. And in this particular case, would it be fair to say that it did not come back as no insurance? It came back as unconfirmed, which is different, right? Her answer was it came back as unconfirmed, correct? Yes. Now, this is where another lawyer might leave it alone, but I am verifying. So I asked the next question, and that is different than when it says no insurance, right? And her answer was correct. So what we have done with the ALR is we have solidified that there is only one offense. And then we have solidified in concrete with multiple questions that no insurance is different than unconfirmed insurance. And there are three separate and distinct responses the computer reads out. Are you following with me?
Yes.
Makes sense, right?
Mm-hmm.
Now, what do you think that person did when they testified in the actual motion to suppress hearing? Because we won the ALR. Now we do our motion to suppress. We say, Judge, you should throw out this case because there should be no other evidence because the stop was bad. What do you think that that officer testified to when asked the same exact questions?
did they have a different story? Did they say, so now they're coming up with a different story?
So now, remember, the only thing that has changed is they've had a chance to talk to the DA.
Mm-hmm.
And the DA knows that they need them to say unconfirmed equates to no insurance, because that otherwise they lose. What does that officer do? That officer got on the stand, said there are only 2 responses, not 3, and unconfirmed means no. I walked up there. I said, I'm going to read this out loud. You tell me if I've read this incorrectly, and I read it for her in verbatim. And after I'm done reading, I said, did I read that correctly? The officer says, yes. So, officer, you have changed your testimony. She has to say yes. And in that particular instance, and I said, and the only thing that has changed between you giving truthful testimony to me under oath and you giving different testimony today, remember, I don't say truthful, I say different, is the fact that you've had a chance to meet with the prosecutor. Yes, that's the only thing that has changed. So as you can see, I put it on there. The officer attempted to backtrack. She doubled down, stating only 2 possible responses. Then the state tried to do what I told you about, introduce other traffic violations and say, well, they didn't use a blinker. Nope. Under the Duran case, quoted for you there, you cannot use things that you did not see in order to justify the stop. If you would go to the next slide. This is where the court comes in. They grant the motion to suppress, and they found that the officer's testimony regarding this stop was contradicted by previously sworn testimony. Ladies and gentlemen, the ALR. And in the conclusions of law, the testimony given was not credible because they said something different than what they had said under sworn oath testimony in the ALR. I cannot stress this enough. ALRs are the single greatest weapon you as the defense lawyer have in a DWI. In no other offense do you get a chance to talk to the officer about what happened prior to. See, in civil law, they have these things called depositions. We don't get those in criminal. Mm-hmm. We have no idea what the officer is going to say other than what they put in their police report most of the time. However, in a DWI, you can question the officer. Ladies and gentlemen, these are just 2 examples of what and how you can use ALRs to your benefit. If you have any questions, reach out to me. If you're a lawyer and you don't know what to do, reach out to me. If you're a client, definitely reach out to me. An individual charged with a DWI or any other offense, reach out to me. My name is Mark Lassiter. You can find me at www.lomtl.com. You can reach me at mark@lomtl.com, or you can reach our office at 214-845-7007. That's it for ALRs. I will see you next time with Lacey G, the Top G.
What a certified badass Mark Lassiter. There you go again.
Digital.